Ladies and gentlemen, please welcome Minister of State, the Departments of the Taoiseach and Foreign Affairs and Trade, with special responsibility for European affairs and data protection, Mr. Dara Murphy. The floor is yours.
Well, good morning. That's a great introduction. Thank you very much, and I'd like to thank the IAPP for having me here this morning. And it's funny, you know, these things that we put up. There seems to be one agreement, whether you want to call it the right to be forgotten or whatever else. Whatever politicians say can never be forgotten. We're definitely in the group where there's agreement. And I'm delighted to be here at this very important event and to thank, as I said, the IAPP for the invitation. And I suppose I just want to talk to you briefly both about developments in our own country in Ireland, the European Union data protection regulation generally, and I suppose our own new data analytics centre and our Magna Carta for data. My own appointment about 7 months ago now was as the first, as was correctly said, European Union country to specifically allocate a Minister of State with responsibility for data protection. I'm also the Minister for European Affairs, which has obviously a significant role in European Union politics, and the department is co-located, I suppose, in our Department of Justice, from the crime element and from the policy element in the Department of the Taoiseach, which is our Prime Minister's office. Ireland is very fully aware, of course, of the importance of the space we're moving into, the importance of data protection. We have in our country 29 of the top 30 digital companies in the world, 9 of the top 10 born on the internet companies. In fact, many of them have their European headquarters in Ireland currently. So one of the key priorities that we set when we had our reshuffle a number of months ago was to, I suppose, considerably up the role and the importance of data protection within government. So we have doubled, for example, our expenditure in a data protection office. We've opened a second office in Dublin and significantly increased the number of staffing. So as you will be aware, by the end of this year, it is estimated that there will be almost 5 billion connected things in circulation, which will rise to 25 billion over the next 4 years. The Internet of Things, of course, is here, and it's growing very, very quickly. Against this measure, I suppose, we finally in Europe have moved towards moving with more energy and more speed with respect to the data protection regulation. I'll come to that in a minute. Domestically, and I suppose every country is dealing with this issue in a different fashion, we have put in place an interdepartmental group to look at data protection. You'll be aware at the moment, even in the European Commission, there are 3 commissioners, all of whom have some role in the digital or in the data space: Commissioner Ansips, Oettinger and Jourova. So we're trying, I suppose, to give a single point of contact for our departments, whether it is in the justice element, whether it is in how our departments exchange data, and of course some of our large data holding departments like you would have here and everywhere else in Europe, our departments of health, education and social protection. The theory is, I suppose, to have a shared and common practice across all of our departments and allow, I suppose, to deliver an effective public policy through the benefits that can be accrued from data management, data analytics, and indeed data sharing. And I suppose the objective is to try and find the correct balance between the potential there is in sharing data and the vital importance in protecting our citizens' rights through privacy. So we have also established a data forum which brings together data privacy activists, industry, key academics, both from the legal and indeed from the technical area. And I suppose the parallel ambition is that we will continue to grow within the analytic and the data analytic space to continue to grow our country as a hub for technological investment and all that comes from that, from job creation and research and development. Just briefly, and Mindy's going to keep me honest on the time because we're going to have a little Q&A, and I'm always kind of worried when you're the last speaker in a session because I can sense the ambition for coffee and all the rest of it. But since my appointment, I suppose, the pace of the European Union data protection regulation has picked up speed. Now, I'm talking about speed at a European Union level of speed, which is different perhaps from the level of speed the rest of us would envisage. Since our presidency, it has been a very key area, and we are very, very strong supporters in Ireland. And in fact, I should say that the Irish position, the United Kingdom position, the Dutch position, and another number of European countries is indeed very, very similar. There's almost no difference, in fact, between the Irish view on most elements of the data protection regulation and the view that there would be here in the UK. We all are aware that given the remarkable speed and pace of technical change, that the fact that Europe is operating under 1995 laws is, to be frank, ridiculous. It was 8 years before companies like Google or Facebook even later appeared. So the rules, the laws, the directive we have is not fit for purpose. And we consistently hear our commissioners in particular talking about Europe needs to be placed to take advantage of technological developments. And we must, of course, do this while ensuring that we put the rights of the citizen at the heart of everything that we do. So therefore, it's vital that the new rules we put in place are workable and that they do not increase. Ideally, they should reduce the levels of administrative burden and provide consistent applications of the rules that will create the right environment to create jobs and growth while also protecting civil rights, digital rights, and data protection and privacy. We have been strong supporters of the principle of the one-stop shop. And from the outset of negotiations, we have made that very clear. This new system will make it easier for European Union citizens when it comes to enforcing their rights across our 28 member states. As you know, under the regulation as currently proposed, any EU citizen will now be able to go to their national data protection authority for complaints covering breaches anywhere in the European Union. The one-stop shop, if it is implemented correctly, will also be a huge benefit for companies. It will allow a company that has a presence in more than one member state have a single regulatory point of contact. This is vital if we believe in any sense in the digital single market and having the capacity for businesses to function here in an efficient manner. This new citizen must, crucially, protect against delays and additional costs for both citizens and businesses. And I think at this time it is vital that Europe does not send the wrong message as to how we conduct and do our business. Now, we have seen significant progress, but there is very, very much more. There's much more work that needs to be done before June's crucial meeting in Luxembourg, when the Latvian presidency hopes to see negotiations concluded. But there are a significant number of areas which will have to be discussed. The right to be forgotten, and I'm now very self-conscious about using the term the right to be forgotten, and of course profile as well, are both areas, complex areas, and they raise the question, of course, between the balancing of rights. In relation to profiling, we support the current proposals, but we need to ensure that we don't stifle the potential for innovation. Our preference is for improved transparency and a prohibition on discrimination to be included within the regulation. Can I just say it's fascinating when we talk about the rights, the freedom of expression. We have significant engagement at ministerial level with the 27 other member states, and indeed quite a significant interaction as well, of course, with politicians from the United States of America. And what is striking is the cultural difference and differences that we have as a group of people on either side of the Atlantic when it comes to this competition and balancing of rights. Certainly in the UK, in Ireland, and even more so in the United States, the ambition to have strong laws around freedom of expression, freedom of the press, are very much to the forefront. As you move across into the European Union, and there are many cultural reasons for this, privacy law becomes a much stronger motivator from the political systems and from the government systems. And I think we need to understand the dynamic, and we need to see exactly where our partner countries are coming from in this space to try and understand their histories, which are different, I think, from the histories that we have, perhaps as you push across further west, and to explain and to encourage, and indeed, where required, of course, to be willing to compromise. With regard to fines, we support in Ireland fines that are fair and that are proportionate, but we do need to avoid having exemplary fines. And again, we need the regulation to be clear so that people know exactly what is proposed and what is likely to be the case as they go through a process. We very strongly support, of course, the principle of privacy by design, which will ensure that data protection safeguards will be built into products and services from the earliest stage of development. And here again, I think particularly in many government departments in many states in Europe, data protection privacy has come at the end of various processes and laws and rules and regulations. And we need to see everybody, whether it is involved in business or in the state, having the issue of data privacy at the beginning of the process so that it's designed into the very architecture of whatever new regulation is coming down the road. Savings for business, again, the numbers you hear sometimes are astronomical. They're naturally very vague. It's a bit like the potential money that can be accrued through TTIP. But some of the figures are greater than a saving of in the region of 2 to 2.5 billion euro a year, which even a proportion of that, of course, is a huge amount of money, particularly in the context of a continent that has been starved of growth over the last number of years. If I could just briefly turn, am I okay on time, Mindy? I'm hanging it together, good. I wish to turn your attention to the very important area of data analytics and indeed digital growth in itself. The reality for Europe, and I mentioned that we have 29 of the top 30 digital companies in the world in Ireland. There are very many of them, of course, based here in the UK as well and in other parts of Europe. Virtually none of them, however, are European. They are all American companies. So we have got to shift the balance back towards this continent and the potential that for the next generation at least, that some of these new companies and businesses will be European. Ideally, they will be Irish, but we can concede across the Irish Sea a little bit to the UK as well. This growth will not come from European protectionism. Large American companies are not bad companies. They will not be, I suppose, surpassed or emulated through protectionism. They will be emulated through innovation and through competition, and crucially, I think, through research and development spending here in Europe. To that end, we have the largest single ever investment in Ireland is in our Insight, our data analytic new company. It brings together 4 of our universities and about 30 of the businesses, 30 companies as well. We've spent 85 million euro on Insight. It's proud to say it's now one of the largest data analytic centres and analytic hubs in Europe. And last January I had the pleasure of speaking in Brussels at the launch of Insight's white paper, which is called Building a Foundation of Trust in Big Data, a Magna Carta for Data. So they're very, very ambitious indeed. And it addresses, I suppose, the need for businesses, for governments to approach big data and data analytics from a consumer trust perspective in the very first instance. So for Ireland, for Europe, and to realise the full potential of the 508 million people who share this this great part of the world that we're all very fortunate to live in, we need to ensure that citizens have a very high level of trust and confidence in our digital environment. So therefore, I have no doubt that Magna Carta and other such bodies across Europe will be of huge benefit to the citizens that live here in Europe. So, in conclusion, we are living in a world that sees the enormous potential that technology brings to us. And we have to, in all our discussions about data protection and privacy, also be aware that there are people who are benefiting, whether it is in the health sector, whether it is in the education sector, and so many other walks of life, from the magnificent freedoms, from the magnificent advances that has come from digital and technical advances. And as I've said on a number of occasions, it's crucial that we work very hard to get the balance right, and that balance can be achieved. And in particular, it is vital that industry professionals, leaders like all of you, give time to come to events such as this, listen to your peers, I suppose take on board their considerations and their objections. It's very rare, I have to say, even in some of the discussions with countries who we are almost diametrically opposed to or ideologically opposed to, that people come in bad faith, that they don't have a reasonable point to make. And I think certainly, while in certain elements of the data protection regulation, particularly the area of appeal, we have concerns in Ireland, they have concerns here in the UK and a number of other countries. I think through this laborious sometimes process of consensus, which people can be critical of within the European Union, the reality is when you walk out the door of one of these European processes at the end of a regulation, you still have 28 member states signed up to something, and that in itself is very, very powerful. So I'd like to thank the IAPP I will take questions, for inviting me along today. And Mindy has our microphone, and I'm more than happy, yes, to take questions. So thank you very much for listening to me this morning. Gur Mágat. Thank you.
Thank you very much. It was a very interesting speech. I received rumors from Brussels that the concept of pseudonymization will not be any longer really supported by the Council. Could you please share some insight with us about this?
Well, you won't be the first person who's heard a rumor from Europe. I didn't see where you are actually when I was getting the water. Yeah, I mean, there has to be huge potential in pseudonym. I have a problem with the pseudonymization. Anything really that can allow the potential benefit to be derived from data that allows anonymity for people to be protected, there has to be huge potential within that. There is, of course, a fear, given the reconvertibility back that's implicit, that you're actually defeating the purpose of the pseudonym in the first place, and that data should be anonymized completely. But look, these proposals are being discussed as we speak. I think in that particular case, we're very much in the area of if we go too far, we will be completely stifling this part of the planet with respect to research, development, and certainly from my point of view and our point of view, I would be concerned if there were to be any sort of further dilution in the proposals that we think at the moment are quite balanced. But what you often, I always wonder, should I say these things in public forums? I always wonder about some of the rumours that come out. They're out to, I suppose, to test the water.
I agree with you that this quite often is the idea of such a rumor, but if we talk about privacy by design, and if we take privacy by design very seriously, then pseudonymization, or if you like the term coding, for example, is a very important and crucial part there. Mm-hmm. And is also understood on the other side of the Atlantic. If you go to HIPAA, that's the federal laws that protect health information, the limited data set is there exactly the same concept. Mm-hmm. And we should be very careful if you would say goodbye to this concept in Europe, because fully anonymous data, if you talk about age of big data, do not really exist any longer. So we need a concept that support research activities with a form of a limited data set, where eventually the term pseudonymization is not really the best term.
Well, the term may not be the best term, but I suppose the principle of allowing that balance occur, whereby, but I mean your point is correct. I mean it will either function properly and give full protection, or it won't, and that will be back to the privacy by design element about the terms and conditions, and I suppose ultimately back to the confidence that people will have. But you have to remember, in most areas, and the area you've picked is one of the areas where there probably will have to be some latitude for medical research, the health area, but within privacy design, the explicit consent of users will be required, whether data is anonymized or not. In many areas will be back to the user's decision.
But we have to be extremely careful there, because in the health industry, especially the pharmaceutical research activities, we have the concept of protect the identity of the study participants since 1947. And if you would now try to destroy it with the data protection regulations, that would be really a shame. And that is why we have to be extremely careful with what we are doing there.
I agree with you. I can't see the reason in the pharmaceutical industry why it would have to be the pseudonym form would have to be used, though. I think in that instance it should be anonymized.
Yeah, but for safety reasons it's not possible, because the reason why you use coded data is that the pharmaceutical industry do not know the identity of the patient, but the physician knows the identity. And if you have a serious adverse event, what unfortunately happens from time to time, you have to be able to immediately re-identify the study participant. And therefore you need a code. If you would have fully anonymous data, you could not any longer identify the patient. For safety reasons, we need this. If therefore
you need it, but you're back into the data retention space here now about what periods and what time and what stages of the specific data is at. I mean, no, it's unlikely to be one specific set of for one industry.
Well, once again, it's not the requirement of the pharmaceutical industry to have the data coded there. It's a requirement from the patient, because if they have a problem with their health, they would like to be secured. And if you cannot do this, and with fully anonymous data you cannot do this, therefore we have to be extremely careful what we are doing there. So that is why the European Parliament introduced the concept of pseudonymized data. And to be honest, the Council so far did an extremely good job to even implement a form of a concept of framework, like code of conduct or so. If this would not be any longer supported on this side of the Atlantic, then I see a big risk, especially for the pharmaceutical industry, because on the other side of the Atlantic, we do at the moment exactly the opposite.
That's right. As I say, I mean, I think it's going too far to say it's not going to be supported on this side of the Atlantic, though. But it is a matter for, as you can see, fairly detailed discussion. Any other questions?
I'd like to bring us back to Article 7 and the right to be forgotten and to erasure, which you just touched on, because I'm interested in what you think the tone in Brussels is around this, bearing in mind the cultural differences that you highlighted, and I also feel very respectful of in Europe. But is there appreciation around Article 7 to the rights of individuals to have access to good journalism and free journalism, as well as the rights of individuals to be forgotten, if that's even possible? I mean, I dislike the phrase as well, because it seems such a simple provision. But as we know, Article 80 is being watered down a little bit, and this simple provision that had its roots around perhaps protecting teenagers who didn't like their social media pictures has much more far-reaching effects, as we're seeing at the moment. It's almost like a political tool in many ways, and yet I'm not sure. I don't know what's being spoken about in the rooms in Brussels, and it'd be really interesting to hear your view on this.
Well, firstly to describe it as a view from Europe would be that there are many different views. From all sides. I mean, it strikes me. It has always struck me that, what we had was a European Court of Justice ruling that just pulled the first piece of the thread, and as you pull it more, the whole garment has sort of to come away, and now it's being stitched back together. I mean, as I say, there's real clarity and acceptance that when you're talking about postings by underage young people who may have made a mistake or whatever else, and there's real clarity about, I suppose, directing very large multinational search engines as well and the resources they have. And I do feel there is a political element to this in some quarters. I think, to be blunt, I think there's an anti-American element to it. I think there's, as I said, there's sometimes a simmering protectionism, and then there's a more understandable ambition, in fact, that there would be greater, I suppose, competition within the market, and indeed that Europe would play a part within that competition. So the third part is more understandable, or more reasonable than the first two parts. And then you move to the other side. I rather flippantly mentioned politicians, but they're a good example. Journalists as well, I suppose, would be in another category whereby, it is vital for democracy in Europe that the concept of freedom of expression, freedom of association, that is protected. And I suppose we have a job in certain countries to make the point that, okay, privacy rights were very, very much hindered during a period in Europe's history, but so were other rights such as freedom of expression. Both rights were actually removed, and to try and, I suppose, focus not on the big names and the many billions of dollars that they take out of Europe, but rather the underlying rights that they support, because these companies are making advertising money because hundreds of millions of Europeans use them many, many times a day. That's a choice, a free choice that's made by all of us. So I suppose the sense I think that I'm getting is that there is a sort of a gradual acceptance that we do need to move to a greater balance, and that the concept of the right to be forgotten, and as you say, I mean, it was never a sort of a term that was meant to define a European policy, but that we also have to enshrine within the data protection regulation, in fact, all of the rights that there is better balance. And I think we have done quite a good job, particularly, if I may say, from Ireland and the United Kingdom and a number of other countries, in actually making this point reasonably. But it needs to be made, because it's not just important for people in Britain or Ireland. It is just as important for people in Poland or wherever else they may be. Now, Poland's a bad example, actually, because the Polish government actually supports the position we have here in Ireland, the United Kingdom as well. But I mean, in the East generally.
I'm sorry,
we're going to have to wrap it. You have a quick question? I can take a quick question.
Okay, very quick.
Yeah.
Everybody.
These are always dangerous, the quick questions.
Super quick. What can the Irish government do about the fact that the competence of the Irish Data Protection Commissioner seems to be unfairly challenged by other data protection authorities in Europe?
Well, they're not unfairly challenged. We have a very strong tradition of independent courts, Director of Public Prosecutions. We will be, under the new regulation, bound by the exact same laws as they will in every other member state. And anyone who feels a judgment of the Irish DPC is erroneous in any way will have recourse to the courts. We have doubled resources. We've opened a new office. And I think we will show beyond any doubt that Ireland will be more than capable, willing and ready to regulate in the best interests of our citizens and the citizens of other parts of the European Union. We're very proud Europeans, and we won't be found wanting. So my concerns are zero. It's my job to get them the money. So thank you very much indeed. Thank you.